I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job, but at this point, we just need to get the case set for whatever it's going to get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for trial.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay, all right, then I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion.
Okay.
Because I would consider that new, obviously, if he has to sit and wait for another trial docket. Okay,
Thank you.
all right, thank you.
You there? Good to see you.
That's an order for a setting.
Well, no,
Sorry.
Mr. Gertiev, Giovanni Coleman. Morning.
How are you?
Good. How are you?
See how it goes after this.
Yeah. Right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. And so we're asking for.
And Judge, if I may, I just put my spin on that.
Please.
I would,
Because, and here's
I
my
would not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these self-elevated first degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're gonna do.
doable.
You've been on since last May. So we're record. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, but there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before. Ask you to keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations was.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving and then causing the vehicle to crash.
We naturally kind of disagree with her version of the facts.
Can't hear you, Mr. Becker.
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McQuaid were in a relationship, and this was a fight that escalated. changed since the last time is he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron
Electrical.
Electrical. He's a electrician and would go there and work and live at home with his friends. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm 14 months into your representation. I'm last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not, and then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This
for
will
that.
be the last one.
Okay.
Okay, all right, you go back with the bailiff.
And that should also dispose of the co-defendant reporting findings as well. So
Okay.
you can kind of keep them staggered and then maybe it would take your June one.
Thank you. Jacorian,
Only-
thank you.
Okay.
Make sure you make that notation for me, please, ma'am. And did you get in touch with Mr. Cole? You're charged in cause number 25 DCCR 0211 with the state jail felony offense of solicitation of prostitution. And that's from December 19th of 2024. And how do you plead to that charge?
Probably. Probably.
Guilty.
Are you pleading guilty freely and voluntarily?
Estás aplicando culpable libre y voluntario. Y tienes que decir sí o no.
Free, nobody's making him plead
Que
guilty.
nadie está diciendo que tienes que decir culpable, ¿verdad?
Answer out loud for her, please.
Yes, Judge.
Are you pleading guilty because you actually did what they charged you with?
Y estás diciendo culpable porque existe lo que le está diciendo que existe. Que sí existe el cargo.
Sí, culpa.
Yes.
I have here on the tablet some documents that have your signature on them
Tiene unos documentos en mi tablet que tiene su firma,
that the state's marks as exhibit number 1.
que es el
Before you signed these, did you go over them with Mr. Kimmler and the translator?
Antes de firmar esos documentos, sí te explico todo en español y su abogado también.
Sí.
Yes, Judge.
Do you fully understand those documents?
Y usted entiende todo que firmas.
Sí.
Yes, Judge.
Do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving any right to appeal?
Y usted entiende que si ella va con lo que firmaste que estás dejándote derecho para apelar el caso.
Yeah.
Yes, Judge.
It looks like the agreement that you've reached is for a 3-year deferred probation with a $300 fine.
Y lo que firmaste 3 años de probation y con una multa de $300.
Sí.
Yes, Judge.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest
Si usted no eres ciudadano, una publicidad de culpable,
may result in your deportation,
se pueden rechazarte,
exclusion from admission to the country,
salir del mundo,
or denial of admission or denial of naturalization under federal law?
que no se pueden- que sí entiendes eso.
Sí, sí.
Yes, Judge.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Torres Lopez is not competent?
Not enough observed, Your Honor.
Ms. French, what's the state's position with regard to waiving pre-sentence reports?
State will waive, Your Honor.
Right.
We waive also, Your Honor.
Right, states one's admitted then. Mr. Torres Lopez, I'm going to find that you entered your plea of guilty freely and voluntarily.
Diciendo que usted entró su pecado libre y voluntario.
find that you're mentally competent and you understand the nature and the consequences of your plea.
que usted entiende lo que está pasando en el momento de su caso
Find sufficient evidence to find you guilty.
y tenemos suficiente información para ponerte culpable.
However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do everything you're supposed to on probation, this is a great opportunity because you do not have a felony conviction on your record. If you violate any condition of probation, though, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand?
Yes, Judge.
I'm handing you the trial court certification that shows that this was an agreement I followed and that you've waived any right to appeal. Before you leave today, you'll need to talk to probation at the desk over there. And if you'll just help them get that information.
Yes, ma'am.
Thank you very much. You can go talk to probation now. Thank you for taking care of this. Jennifer, ALJRI. ALJRI.
Jennifer.
Yeah, thanks.
Sorry. Yeah. It's okay, I can get it.
ALRAJA. It doesn't want to come out right.
It doesn't. What is it? AR.
Look,
A-
hey Jennifer, when you're done, come tell her how to spell your last name.
ALRAJI.
There we
Thank
go. See, it's easy for her to say.
And she can enunciate.
All right, Mr. Coleman and Mr. Gertz on Felicia Freddie. It was set for this afternoon.
Do something on the tab.
All right, so you are Felicia Freddie. Just wait just a minute. I'll be finished.
Okay, cuando llegue a salir la opción. Ese es el de 820 meses. No, nomás van a ir a otra predicción, pero das todo esto y ellos van a tener todos los cosas que están diciendo en un parte, cada mes para lo que ¿okay?
All right, this is clause number 24, DCCR 1390. Thank you very much.
Yes,
And so Ms. Freddie was previously in court. She's on probation for evading arrest or detention and
Judge, I'm sorry, Rob, it's actually, we reduced it to a fleeing initially.
Eluding.
And fleeing or eluding, I don't know why it keeps coming up as the evading.
okay. And so it's a misdemeanor,
That's right.
put on probation. There was a motion filed, she pled not true to the counts in that motion. We were here for, or we're actually set for hearing this afternoon. It's my understanding you guys have visited and there's an agreement reached. Is that correct?
Yes, Judge.
Yes, Judge.
So tell me what's going on.
I guess the way to call it would be a little bit of unusual agreement, but Mr. Coleman has agreed to dismiss the motion to revoke probation in exchange for essentially two sanctions. One would be having the court order her to do a day in jail, but with credit for a day in jail. And two would be to complete an anger management class through the probation department.
And it's the state's intention to dismiss the motion. Those would just be sanctions through probation, not because of me making any findings in that motion, correct?
That's correct.
right.
Essentially an amendment to her conditions of probation.
So, Ms. Freddie, what that means is that motion to revoke your probation is going to be dismissed. You're still on probation.
Yes.
It's going to be now a condition of your probation or a sanction for the allegations that you serve 1 day in jail. You will get credit for that day when you were arrested. Also, you will now be required to successfully complete an anger management class or program. I do want that started within 30 days. It's a kind of a lengthy several week program. I don't want you to put that off. I want it started within 30 days, do everything else you're supposed to on your probation. And this will hopefully just be a hiccup that goes away and you'll still be able to have that deferred probation without any type of conviction.
Yes.
Okay. And I know because it's a misdemeanor, it's also not a long probation. And so you need to get that anger management done as quickly as possible.
She's 1 year complete, Judge. And
Okay.
so, of a 2-year probation.
Perfect. So there's plenty of time for you to get that done. So get that started, get it over with, and then every property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, Your Honor.
I have, Judge.
Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out and she's helping run a rehab center in Lafayette and it's going to become part of his life. He's got 2 uncles here. So he has, they're in the courtroom. He has strong family support,
Okay,
a lot stronger than what that says.
good. Thank you. I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, Your Honor.
Okay,
But I'd have to be a psychiatrist to truthfully answer it,
Okay.
correctly answer it. You know.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I was
thank you.
just saying.
All right, so they'll get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Your Honor. He be released today.
He should be,
Yeah.
yeah, as long as there's no other hold that misdemeanor, once if there's nothing else in the other county. But if it's just this, yeah, you should be released today and you'll get some instructions today before you leave the courtroom for probation to tell you exactly what to do when you're released, okay? Okay,
Thank you, Your Honor.
yes, sir. Ms. Delays, you have Jeremy Alexander.
Yes, Your Honor.
It's out. Good morning.
Good morning. Rainy morning.
Yeah,
That's a lot of.
very rainy, a lot. Morning. Good morning, sir. Are you Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly or disabled individual. And what is the announcement?
Your Honor, we're going to ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm going to double check.
Okay, so if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Ms. DeLage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay, you go back with the bailiff.
Just thank you.
Thank you, ma'am. I could just put a notation, videos specifically, yeah. Brian McWade, Mr. Macon.
Good morning, Your Honor.
Good morning.
Sorry.
Yeah. Good morning, sir. Are you Brian McWade?
Yes, ma'am.
And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was time.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right.
April
I usually
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence. Other than that, it's just a matter of if the case is going to go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Neutron, right? As an electrician.
Okay. Ms. Malfino,
Judge,
does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. But you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's originally was.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled through this morning, but we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers changing in
Right.
the computer. They print out different numbers. Take a minute.
Mr. LeBlanc, looks like are you working on Derek Schinkel? Okay, I'll hold it. Mr. Rojas, you have Vicente Gloria.
We need them.
Hold on a second.
I'm gonna ask for a reset. I'm trying to run out some more information.
Okay, we're gonna reset Vicente. We'll reset Vicente Gloria. John Hill. John Hill. Good morning, good morning.
Good morning.
Good morning, Your Honor.
Good morning, sir. Are you John Hill? And let me get this pulled up correctly. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Hill, in clause number 22-40932, I have an amended motion to revoke your unadjudicated probation. Shows that you were placed on probation March 28th of 2023 for the third-degree felony offense of forgery of a financial instrument. Is it a third? The docket for some reason has state jail beside it.
It looks like it's a third, Your Honor, on the motion, on the admin.
Okay, I just want to make sure I'm saying the right thing because it has SJ on the docket.
It was enhanced, Your Honor.
Okay, so it was a state jail felony forgery that was enhanced to a third degree,
Yes, Your Honor.
and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of theft of property less between $100 and $750, April 15th of 2026. Is that true or not true? True or not true?
Judge, we can drop count 2. It's duplicative. It's and juries have it. We're committing theft. I'm sorry. We're going to drop count 2 just because it's duplicative.
Count 3 alleges that you're behind in your court assessed fees. As of April 16th of 2026 in the amount of $10,859. Is that true or not true?
True.
Count 4 alleges that you failed to report as directed to the probation department for the months of April and May of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas, and that you were in Orange County June 1st of 2026 where without permission. Is that true or not true? True. And then count 6 alleges that you failed to immediately report the arrest for theft of property to your probation officer. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
Give me just a second. I need to look back at some things to understand. Looking for the PSI. Also.
Is your question about the 3, Your Honor?
It's actually a third degree. It wasn't enhanced. It was not
Okay.
enhanced. It was a third degree forgery. The indictment was amended back when he entered that plea in March to show that it was just the caption that was incorrect. Okay. Got it.
I'm sure.
What is the status of the new theft case?
It's pending, Judge. When this is over, we're gonna take him down the hall and give him plead to that one as well.
I know.
I believe it's set this morning also.
I realize most of this history is very old. I just don't know that I love a 45-day sanction for someone with this kind of history for the same type of, I mean, it's a theft.
And Judge, if I can, the thing that he was stealing food, It's not like he was out stealing stuff to go, alcohol or anything like that. He and his son have started a trucking company. He is going to be gainfully employed when he's released. And I think, as far as I know, the court's not really concerned about the money, but he did have an accident which made it hard for him to stay up to date on probation fees. And he's trying to turn his life around, Judge. I think like I said, he started the trucking company. That's a step in the right direction, I think.
All right, so Mr. Hill, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement is for me to continue you on probation, but order a 45-day sanction as a condition, and with the, I guess, the caveat that you're going to go take care of the other case. There's going to actually be a plea. It's not getting dismissed, correct?
That's correct, Your Honor.
Is that your understanding?
Yes.
Obviously you can tell I don't love this agreement. I want to make sure you understand if I follow this agreement and you're in trouble and you're in here again on another motion, it's not going to go this way. Okay.
But I'm embarrassed.
All right, I'm going to, state tenders number 1.
No objections.
It's admitted any evidence that Mr. Hill is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order that 45-day sanction. And you will get, agreement is for him to get credit since the motion, right? The arrest on the motion.
Yes, Your Honor.
So you will get credit on that 45 days for any amount of time that you've been in since you were arrested on the motion to revoke. So not from the original part of the case, but just since you've been in on this. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you have waived your right to appeal. Take advantage of this today. All right. Good luck to you, sir.
Thank you, Your Honor.
You can go back with the bailiff.
Yes, ma'am.
Pedro Martinez.
Martinez, Pedro.
Yeah. Good morning, sir. Are you Pedro Martinez?
Yes.
And this is cause number 26 DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Margaret Samano.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her, known information I had. I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us from one, she non-prosecuted, so to speak, in the offense material. And two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but On the other hand, the fact that the defendant has been in custody, I feel with that information, it is my duty to, at this time, move to dismiss. And if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating, makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Judge. I'll send it out.
I'll sign it as soon as it comes through. Jamie Story. Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tenders number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you can go back with the baby.
Great, thank you.
Judge, my last one is Willie Pugh. He was set yesterday for a suppression hearing.
Let me just. Okay,
He was set yesterday for a suppression hearing. The officer is unavailable. We set him today to thinking about setting a bond, but he has a parole hold on him, so he can't go anywhere anyway. So
oh, well, could have,
And I
I'm
didn't.
over.
Yeah, I
And
didn't, I didn't
He
think, I
had
didn't,
that
yeah.
hold and that reset was based on my request, so I thought that would be fair for him to ask for it. I did speak with Mr. Rojas, Judge. This is Sergeant Lisenby, who the court is familiar with. He may be on a very long on-the-job injury. I've asked Charlie if he would agree to allow him to Zoom, and I'm going to see if we can get around their requirements that they cannot testify when they're on that.
Okay.
And he's
That's no-
saying has agreed, and so hopefully when it's set next, just in the ordinary course, I will set that up if the court would allow, and hopefully that'll work.
So next time it would need to be though for the motion to suppress.
Yeah.
So we would need some time. We need to find a
An hour.
Couple
or
hours,
so,
okay.
yes.
if you'll make a note on Pew that we need to set it back for the motion to suppress on a specific day. And if
And
he
even at 11
can't,
o'clock, it would be, I think we could get it.
Yeah, I don't think it's gonna be too long.
okay, just make that notation. And if for some reason they're not going to allow that, then let me know. We'll see what we do. Okay. Maybe I can,
Maybe your phone call.
maybe that'll help. Thanks.
Thank you.
Did, Mr. Nichols or Miss Malfino, which one of you are,
It's mine. I've asked it to be brought down, Judge.
okay, you're still waiting on it?
Yes, sir.
Okay. Mr. Parker, you have Jesus Lugo. Do we have him or is he in the beds?
Good. I just need to thank the record. It's better case than most time.
Okay, and do we have him or is he?
No, he's
No,
not.
okay. Go ahead. This is cause number 26,
No.
DCCR 0345.
Judge, it's come to my attention from my investigator that Mr. Lugo pled and is still waiting to be sentenced on the federal case that arises out of the same incident. Had he not entered that plea, we would ask for a reset to wait and see what happens, but I feel confident that because it's based on the same facts and he's entered that plea and they're in the process, that will suffice for this case. And so at this time, I'll dismiss it rather than reading him over and bringing it back because it's the same airlines. So I will file dismissal. I just wanted to give it a little time for that plea to be finalized. He had to be
Well, enough of-
sentenced.
Do you want to wait until sentencing or
I
you
would
feel
prefer that,
confident?
but if you want me to go ahead and dismiss it, I will. But I don't have any intention of ever bringing him back. If you would allow me the time to just have that judgment for my file, that would be great. But if not, I'll do whatever.
Well, you just never know if something falls through or doesn't happen the way you feel like it would be the
Originally,
right.
he was.
If it mattered, I don't object to the dismissal today, Judge.
Thank you, Mr. Parker.
Well, originally he was in Orange County, then we brought him here, the feds picked him up, now he's there. Instead of just round robbing him, everyone wants to dispose of it the same way, it's just he's in their custody, and I don't want him, but if you would allow me time to get that judgment, that would be great.
Do you know when that plea was entered?
At least a month ago.
So maybe let's do a 90, oh, she's gone. Let's do a 90-day reset on Jesus Lugo.
It was entered,
And if you'll make a notation that we're waiting on sentencing in the federal system.
it was before mid-June that he entered that.
Okay,
so
they must sit there. All right, thank you. Dontrell Robertson,
Judge, we're going to ask that that be reset. And then Mr. Smith are talking, and I think we need to talk to the probation department and a couple other things.
okay,
He has a new case and he has 2 MTRPs.
okay, got it. We'll just do a normal reset on Dontrell Robertson. Luciano Sevilla,
I'm going to go through the motion, Judge.
okay. Good morning. Are you Luciano Sevilla Jr.?
Yes, ma'am.
And Mr. Sevilla, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Mr. Parker, will he waive the formal reading of the motion?
Here we go.
Mr. Sevilla, in clause number 22-39617, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2022 for the third-degree felony offense of stalking. And that was a 7-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of criminal mischief, May 23rd of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 2 alleges that you committed the offense of stalking, May 22nd of 2026 through May 28th of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 3 alleges that you failed to, it's really the same.
It is, Judge. This was a motion that was filed rather quickly at the court's request, so I put everything.
Yeah, no, that's fine. I appreciate that. I'm gonna skip 3. Count 4 alleges that you violated a term and condition of your probation by prohibiting the possession of a firearm, in that you were in possession or observed in a video displaying and possessing a shotgun and a red shotgun shell in November of 2025. Is that true or not true? Count 5 alleges that you violated the term and condition of your probation that required you to have no contact with the victim, Cynthia Gonzalez, and that on May 23rd of 2026, you sent text messages to Cynthia Gonzalez in violation of that order. Is that true or not true?
That's true, Mom.
Count 6 alleges that you are behind in your court assessed fees as of June 2nd of 2026 in the amount of $349. And is that true or not true?
That was complicated. I know what I was gonna pay. I never had problems paying.
Well, it was just as of that date. So that's fine. I'll put not true for 6. All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
They're true.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to reset your case for a sentencing hearing, ask the probation department to do an updated report. Obviously, if there's any evidence with regard to the firearm allegation in count 4, we can hear that. It shouldn't take too long if you want to have somebody here on that.
Well, Judge, and just so you're aware, I did contact Orange County DA's office last week. They do not yet have that case. In anticipation of these pleas of true or not true, I reached out to them, also reached out to Detective Taylor at the Bridge City Police Department. I would like to bring him at the sentencing regardless of these pleas for the court. I think it'd be important based on the fact that he's on probation for the stalking. It's the same victim, Miss Gonzalez, in both cases. I've handled it since the beginning of it. So if you would allow us a little bit of extra time, I'd like to bring that detective
Sure.
as well.
And we could do that on a regular morning
Yes,
docket,
that'd be
but
fine.
yeah,
Just
that would
You
be,
note, I'll have a witness or two.
okay. Do you anticipate witnesses?
Yes, my client.
Okay, so we'll just make a notation that there will be witnesses and maybe put this one at 11 for a sentencing, and we'll get an updated pre-sentence report. Anything that you think is important for me to know, get that information to Mr. Parker.
Then I'll give him later.
I understand.
Yeah, just you'll talk before sentencing, and he'll present all that to me on your behalf when we come back. All right, go back with the bailiff.
Come see. You get this.
Arlington Wood.
No, we're not. Oh, you're right.
Morning, Miss French.
Good morning.
I think you were already up here and I didn't say good morning.
I get busy and forget myself.
Very sure.
Good morning. Are you Arlington Wood Jr.? And Mr. Wood, in cause number 25, DCCR 1650, You're charged with the third-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a third degree, burglary of a building, a second degree, another burglary of a vehicle, third degree, and an unauthorized use of a motor vehicle, a third degree, on January 27th of 1986. And after those were final, you were convicted of theft, a third degree, January 22nd of 2019. You guys have marked off second degree, but would
That
it
should
not
be
be a
first.
habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So,
That would be a notice I would make
a
on my
notice,
own.
and that would make it a habitual, correct?
Correct.
So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count one only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all of that? Sorry?
Yes, ma'am, I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? How long, Mr. Parker? What do you say?
I mean, I don't know what I'm gonna provide you other than what I've told you. I'm not gonna have any documentation. I mean, with he's on parole, Judge. He has two types of cancer. He has some health issues and quite bluntly, anytime he gets, he thinks is a destiny. And so, I mean, that's his position, understand it. But I don't know if his position is going to change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial.
Judge, I have the McWade file and you didn't, we can proceed.
Okay, I'll take care of it in just a second. Summer Young.
Summer.
Wonder something here.
I don't know that. I don't know that. I don't know. You're probably right.
I don't know how they work it, but if you'll let me know.
Okay.
Discussion there.
Good morning. Are you Summer Young?
Yes.
And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Young, in cause number 24 DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the second-degree felony offense of assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
Sure.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
Sure.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
Sure.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
Sure.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand them?
Yeah.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
None.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, you know? So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
For 90-day firm.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff.
Thank you.
So
Wait.
is Chip's not going to be here and Tommy's not going to be here, but so on Joseph Freeman, I'm going to number that case, but Mr. Coleman filed something, so I'll get after docket get together with them. We've seen or heard from Giles Cole. We want to start trying to get in touch with him. And I saw Mr. Gertz come and go.
May I approach your honor?
Yes, ma'am.
I emailed Ms. Holmes yesterday evening after I was contacted by Mr. Kindler. And Mr. Torres is taking a plea.
That's what I understood. So are they going to try to get him here to? I think Kelly was going to try to see if they could possibly come this morning at some point, but I don't know if she's gotten that answer. If not, we're going to try to get them over sometime this week.
Okay.
To get that taken care of. She did just tell me that.
All right, thank you.
Mr. LeBlanc on Derek Schenkel. Morning. Good. Good morning. Are you Derek Schenkel?
Good morning. How you doing?
Good. And this is cause number 25 DCCR 1797. And Mr. Schenkel, we've gone through this before, but I'm going to go through and make sure we're all on the same page again. And in that case, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And that's from October 15th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, October 16th of 2016. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a first-degree felony with a minimum punishment of 5 years up to 99 years or life in prison. Do you understand?
Yeah.
And I have a plea bargain rejection that you've signed now with Mr. LeBlanc that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 6-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure y'all have gone over everything. You understand you want to go forward with trial.
Yes, ma'am.
All right, well then we will get your case moved to the trial docket. Mr. LeBlanc will begin preparation.
All right. Hey, thank you, ma'am.
Yes, sir.
You have a good day.
Thank you.
Thank you.
Thank you. Okay, let's see, on Brian McWade. Brian McWade.
A defendant walks into court hoping for another chance, but the judge has already reviewed his history. What follows is a courtroom moment that proves second chances are earned, not guaranteed. The hearing centers on John Hill, a man already serving probation for a felony forgery conviction. But according to prosecutors, he violated nearly every major condition of that probation. The allegations included a new theft offense, failing to report to probation, leaving the county without permission, failing to report a new arrest, and falling thousands of dollars behind on court-ordered fees. When the judge asked whether those allegations were true, Hill admitted they were. Normally, admissions like these can end with probation being revoked and a defendant sent straight to prison. But before deciding the sentence, the judge wanted to understand the full picture. The defense explained that Hill had recently gone through difficult financial struggles. His attorney told the court that the new theft involved stealing food, not luxury items or property for profit, and that Hill had started